that the accused person has no known place of fixed abode, and therefore he is a flight risk. And finally, that the seriousness of the charges which the accused person is faced with present potential or present a likelihood for the accused person to abscond given the potential penalties, the stiff penalties which follow on the event of conviction. The defense, in response to the said grounds, vehemently opposed the application for continued detention of the accused person. They contend that the affidavit in support of the said application is devoid of any compelling reason to justify limitation of the said right to liberty. According to the defense, the affidavit is replete with bare allegations and is lacking in substance, that the prosecution has a duty to not only to make broad general allegations, but to present clear evidence in support of the prayer that they seek. The defense further contended that the alleged threat of interference with investigations or with the victims lacks basis, as it is unclear how the alleged interference is alluded to or will occur in the absence of any information on the potential witnesses, including their proximity to the accused person. The defense also dismissed the allegation that the accused person is a flight risk. They maintain that the affidavit of the investigating officer does not lay clear basis for such contention. They also contend that the mere fact that the accused person is charged with a serious offense with the potential of stiff penalties is not sufficient reason to deny him his right to bail and bond, and that notwithstanding the seriousness of the charges, he still enjoys the presumption of innocence. Question whether the prosecution has presented compelling reasons to merit limitation of the accused person's right to liberty by denying him bail or bond. The prosecution would have this court to curtail the accused person's right under Article 49(1)(h) of the Constitution, which guarantees to every arrested person the right to be released on bail or bond on reasonable condition, pending a charge or trial, unless there are compelling reasons not to be so released. It is manifestly clear that the right in question, though not absolute, may be limited only where compelling reasons are demonstrated to exist. The question which the court is faced with is not an altogether novel question. It is a question that has been deliberated upon by superior courts in numerous decisions, and this court can therefore do no better than to be guided by the wisdom of the higher courts in arriving at a just and fair determination of the issue at hand. The grounds in the supporting affidavit in the application by the prosecution, offences for which the accused person is charged, and the severity of the potential penalties serve as a strong incentive to abscond, and therefore rise to the standard of should be deemed as a flight risk for a reason that the investigators have not established he has a fixed place of abode. Second, whether the seriousness of the offences charged and the severity of the potential sentence penalties is a compelling reason sufficient enough to merit denial of bail and bond to the accused person. Thirdly, whether the prosecution has presented sufficient evidence in support of the contention of potential witness interference or interference with the investigations to merit denial of person. To answer the first question, that is, whether the accused person has a fixed place of abode, this court is not persuaded that he has no place of abode. Rather, the court is of the view that the investigators have not demonstrated what efforts they've made towards establishing his background, social and community ties, and unless it is their contention that the accused person has hindered their efforts or stood in their way in trying to ascertain the said information, this court is unable to agree with the investigators that the accused person is a flight risk for reason of absence of a fixed abode. The second question is whether the seriousness of offences charged and the severity of the potential penalties amount to a compelling reason, and for this reference is made to the case of Nganga versus Republic, 1985 KLR at page 451, where the court stated, and I quote, "The court, in exercising its discretion to grant bail to an accused person under Section 123, subsection 1 or subsection 3 of the Criminal Procedure Code, Chapter 75 of the Laws of Kenya, should grant bail to the accused person unless it is shown by the prosecution that there are substantial grounds for believing that, 1, the accused person will fail to turn up at trial or to surrender to custody, 2, the accused person may commit further offenses, or 3, that he or she will obstruct the course of justice. The primary consideration in deciding whether or not to grant bail to an accused person is whether the accused person is likely to attend trial. In making this consideration, the court must consider, 1, the nature of the charge or offense and the seriousness of the punishment to be awarded if the accused person is found guilty. 2, the strength of the prosecution case. 3, the character and antecedents of the accused person. 4, the likelihood of the accused person interfering with prosecution relations." End of quote. In another case, that is the case of Republic versus John Kahindi Karisa and 2 others, that is 2010 EKLR, the High Court also considered the question of seriousness of charges and potential penalties. And this is what the court had to state in that case. And I quote, "Whether the court will decide the fear and anxiety whatever the court will decide, the fear and anxiety exerting on an accused person's mind during the trial in a murder case cannot be ignored. The possibility of thinking of flight by an accused person facing a capital offense is real and cannot be wished away. It is therefore true that the seriousness of an offense and the sentence for which is possible upon conviction is a matter which can bear on the accused person and can affect his decision to attend trial or not. In that case, the court also referred to an earlier decision in the case of Watoro versus Republic, that is 1991, KLR at page 220 and 283. In that case, and I quote, "The seriousness of an offense in terms of the sentence likely to follow a conviction has been held repeatedly to be a consideration in exercising discretion. If the presumption of innocence were to be applied in full, there will never be a remand in custody. What I think is important for the court to bear in mind, and the reason for the caution to remember the presumption of innocence, is that it would be wrong to lead to the conclusion that the accused person was guilty merely because he had been charged and decide the bail application on this basis. Nevertheless, the seriousness of the offense has a clear bearing, which the court ought to bear in mind as one of the factors influencing the mind of an accused person facing a charge in respect of an offense as to whether it will be a good thing to skip or not, and such a possibility is not out of question. It has happened before in similar cases. I do not mean to say that because other people have decided to leave business, family, and friends for other clients rather than to face prosecution, this applicant will do so. That decision depends on all prevailing circumstances of the applicant. All I mean to say is that the presumption of innocence cannot rule out consideration of the seriousness of the offense and the sentence which will follow on conviction." End of quote. Again, the same question of seriousness of the offense and the sentences to follow was also decided, was also touched upon by the court in the case of Christopher Charlo Katila versus Republic, that is 2021 EKLR. And I will not belabor the quotation, you will find it in the ruling. The analysis of this court from all the authorities that have been cited above on this question, it is clear that while the seriousness of the offense and the severity of the potential penalty is a consideration to be kept in mind in determining the question of bail and bond, it must not be taken in isolation and must be looked at in conjunction with all other prevailing circumstances of the case. The mere fact that an accused person is charged with a serious offense which carries a severe penalty is not an automatic reason for denial of bail and bond in the absence of other prevailing factors which would tend to show the accused person is likely to abscond trial if released. In the present case, the accused person has been charged with offenses under the Counter-Trafficking in Persons Act. However, this mere fact, in the absence of any other factors, does not and cannot suffice to upset the presumption of innocence as guaranteed under the Constitution of Kenya. To hold otherwise is tantamount to a finding that seriousness of charges and severity of potential penalties, irrespective of any other factor, is a sufficient ground for denial of bail and bond. I am therefore not persuaded that the preferment of charges, no matter how serious by itself, represents, looked at independently of all other factors, represents a reason on its own to deny bail and bond. The next question, which the court must grapple with, is whether the prosecution has demonstrated that if released on bail and bond, there is a real threat that the accused person will interfere with the investigations and with witnesses. To answer this question, the holding of the High Court in the case of Republic versus Joktan Mayende and 3 others, that is 2012 EKLR, is instructive. In that case, the High Court, faced with an issue of alleged interference with witnesses, as a compelling reason under Article 49(1)(h) of the Constitution, had the following to say, and I quote, "For purposes of Article 49(1)(h) of the Constitution, a compelling reason hinged on interference with witnesses does not necessarily require strict medical proof. Where assault is claimed as an act of interference with witnesses, since the court is not determining a criminal charge of assault the way we know it in a criminal trial, where there is evidence that a person is accosted physically or otherwise by an accused person, in the case where the person is a witness, it suffices to prove that the accused did acts tending or intended to interfere with a witness. The court is then entitled, if not bound, to infer that the intention of the accused person in accosting the witness had been to dissuade the witness from giving evidence. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying witnesses, either not to give evidence or to give skewed evidence, amount to interference with witnesses, an impediment to or perversion of the course of justice. For greater understanding of this position of law, the court referred to the case of Republic versus Kellett, that is 1975 pre-All England Law Reports at page 468, for the proposition that all that the law requires is that there is an interference in the sense of influencing or compromising or inducing or terrifying or doing such acts to a witness with the aim that the witness will not give evidence or will give particular evidence in a particular matter. Interference with witnesses covers a wide range. It can be immediately on commission of the offense, during investigations, at inception of the criminal charge in court, or during the trial. And it can be committed by any person, including the accused, witnesses, or other persons. The descriptors of the kinds of acts which amount to interference with witnesses are varied and numerous, but it is the court that decides, in the circumstances of each case, if the interference is aimed at impeding or perverting the course of justice. And if it is so found, it is a justifiable reason to limit the right to liberty of an accused. End of quote. In the above cited case, the court felt the need to emphasize the compelling state interest, that is, the interest of the state to bring offenders to book and to discourage wanton interference with witnesses, and the need to balance the said interest against the individual's right to liberty. The court had the following to say, and I quote, "In all civilized systems of court, interference with witnesses is a highly potent ground on which the accused may be refused bail. It is a reasonable and justifiable limitation of the right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. Undoubtedly, a cardinal tenet in criminal justice, social justice, and the rule of law in general as envisioned by the people of Kenya in the preamble to the Constitution of Kenya, 2010. It also recognizes the compelling state interest principle where the state's constitutional duty to bring offenders to book should be free from wanton interference of its witnesses, and it is to be weighed against the right to liberty of the person charged if that person is being accused of interfering with witnesses in his own case. It is therefore a matter of great public interest to allow the cause of justice to run without being hindered by any person, a group of persons, a state organ, or organs whatsoever. Otherwise, the pillar of justice, that is the enabler of constitutional rights and obligations in society, will collapse. And with it will tumble the entire societal fabric, social justice, and the rule of law. That is the amount of preponderant weight that the administration of justice bears and outweighs the right of the fourth accused person to liberty, particularly where he has acted in a manner tending to impede the cause of justice." End of quote. I've also referred to the case of Republic versus Dwight Sagre. I will not read the quotation. You will find it in the ruling. Having carefully considered the various authorities that I have cited in this ruling, a careful analysis of the dicta of the superior courts, a number of principles do emerge to guide the court when it is presented with evidence of alleged witness interference as a basis for denial of the right to bail guaranteed under Article 49(1)(h) of the Constitution. The principles may be summarized as follows. Number one, the acts which amount to interference with witnesses are varied and numerous, and they may be by way of physical acts, for instance, assault or otherwise, threats, but it is the court which has to determine the circumstances of each case if the particular act of interference is aimed at impeding or perverting the course of justice. Secondly, threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amount to interference with witnesses. Number three, the alleged acts constituting witness interference must be perpetrated by an accused person against a witness in his own case. Number four, in order to demonstrate witness interference, it suffices for the prosecution to prove that the accused person did certain acts tending or intended to interfere with witnesses. Mere suspicion and fears harbored by the prosecution will not do. Number five, the prosecution must show a link between the alleged acts or threats which an accused person whose right to bail is sought to be limited. That is to say, there must be a link between the acts of interference and the accused person. Number six, where the alleged acts have been proved, the court is entitled, if not bound, to infer that the intention of the accused person in doing the said acts to the witness had been to dissuade the witness from giving evidence. Number seven, all that the law requires is that there is proof of interference in the sense of influencing or compromising or inducing or terrifying or doing such other acts to a witness with the aim that the witness will not give evidence or will give particular evidence and in a particular manner. Number eight, the prosecution must place material before the court which will demonstrate actual or perceived interference, and it must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and witnesses, close familial relationships between the accused and the witnesses, among others. General averments that an accused person has interfered or is likely to interfere with investigations or witnesses will not suffice. The specific instances of interference or material facts leading to a deduction of interference must be laid before the court and specifically proven. Number 10, the court must balance the compelling state interest to bring offenders to book and to discourage wanton interference with witnesses against an individual's right to liberty. And number 11, the standard to be applied where allegations of witness interference have been brought up, although not one that goes to the standard in criminal cases that is beyond a reasonable doubt, ought to be a standard that is higher than a mere probability, as it concerns limitations of liberty. Having taken into account the principles I have outlined above, the court must now consider whether in the present case, the prosecution has, through the affidavit of the investigating officer, presented sufficient grounds to satisfy the criterion for denial of bail and bond on grounds of witness interference or interference with investigations. The affidavit of the investigating officer contains an allegation of fear of potential witness interference, and there is an alleged threat that was issued by a third party against one of the witnesses or the one potential witness. There is no specific instance of witness interference by the accused person. The contention that an associate of the accused person issued threats to a potential witness, to this I say that the accused person cannot be condemned for acts of alleged associates in the absence of any proof of connection between himself and the said alleged associates. And that the threats, there is no evidence that has been presented before the court to show that the said threats were issued either at the instigation or direction of the accused person herein. General averments that an accused is likely to interfere or has interfered with investigations or witnesses cannot suffice. The specific instances of interference must be laid before the court and specifically proven. By and large, I therefore find no evidence in the present instance that meets the criterion of the foregoing authorities or that satisfies the test of a compelling reason. The affidavit herein invites the court to rely on a mere assertion whose veracity is doubtful, which invitation this court politely turns down. In the end, therefore, I find and hold that the prosecution has failed to present evidence of any compelling reason to merit or justify denial of bail or bond to the accused person. That is the ruling of the court.
Madam, Your Honor.
Yes,
It is us.
Yes, you can make your submission.
Very in the bail and bond terms that he will be able to raise. His father is in court and his mother, they are in court. And because of that family linkage and the brother who is in court also, when we are in the court to see and grant a reasonable cash bail of Kenya shillings 200,000, and in the alternative, a bond of 500,000 shillings. Your Honor, we want not to make this discussion longer, to allow the court to make its decision so that the ruling is not deferred to tomorrow. Yeah. That's all from the defense system.
Date for pre-trials.
In 2 weeks, Your Honor.
In 2 weeks, yes.
That's convenient on our part. Any date. What's that?
The 23rd of October.
23rd of October. Mentioned on the 23rd of October for pre-trial. On the issue of bail and bond, the accused person may be set at liberty upon securing bond of 2 million shillings with one surety of a similar amount, or cash bail of 500,000 shillings with one contact person. The matter will be mentioned on the 23rd of October for pre-trials and for further directions in the matter.
But Your Honor, before you panel, we will want to make a small oral application.
That the accused person